Michele is an information specialist and chief librarian at Austin Health. She's had a very varied career as an information and knowledge manager and has worked at senior levels for multiple for-profit and not-for-profit institutions. Research and evidence-based organisations in the disciplines of health science and technology. She's also held roles in education, sales and marketing, and had a keen sense of curiosity about what motivates her to explore all the nooks and crannies of the information industry. I didn't know there were that many nooks and crannies, but there obviously are. And she has been president of Health Libraries Inc. Since 2013 and leads a diverse statewide group of information sharing professionals. So I will ask Michele to come up.
I thought a little bit of copyright mood music might help you get in the mood. Does everyone recognise that introduction to that song? A raise of hands, nobody? Okay, so you recognise that that is a song called Taurus and it's played by a band called Spirit. I thought that I would open with some music as we all recognise there's some creative content in that genre. A big part of copyright is recognising tangible and intangible elements of our work. So yeah, once again, music's good. Now, I know nothing about music, and for those of you in the audience that are in the same position as me, apparently the tangible elements, and these are things that can't be copyrighted, are the descending lament bass line, which is in both these songs, and they're in hundreds of songs. There's only 4 notes, apparently, in this beginning of this riff that are common, so that's not copyrightable. And also chord progression, which is when 2 notes are played simultaneously or more, and that can't be copyrighted. However, what is copyrighted is the intangible, and that's the style and the exact voicing and the rhythm, and all that together forms a riff, and a riff is copyrightable. So, and we recognise that, and if I heard that as a layperson, I would have really thought that was Led Zeppelin, but it isn't. So the question, and why they're going back to court around this, well, it is to try and work out whether Led Zeppelin has actually used the same riff as the band Spirit. And why now? Well, someone in the band Spirit has just died, and so there might be some money involved. But also what's going on is that, you know, they can prove that Led Zeppelin opened for Spirit in 1968, and I know a lot of you weren't born then, and they played several shows with them, and they were actually played some of their songs, and they also had their albums, so they can unequivocally clearly say that Led Zeppelin had access to the artistic elements of the song Taurus, and as part of copyright, that is where copyright infringement case will base it on. So welcome to the world of copyright, where I didn't know is just not an excuse. We've heard the term intellectual property a lot over the last 2 days. There are different categories of law that protect different types of intellectual property. The 3 main categories relevant to 3D printing technologies in medical practice are copyright, patent and design laws. I'm just going to talk about copyright, and I'm also going to introduce you to Creative Commons. Intellectual property relates to, as I mentioned, the intangible asset, so something that's intellectual, creative, artistic and reputational. So with 3D printing, it's most likely to involve the creation and the use of the artistic work, and yes, it falls under artistic work. And remember, there's a close relationship between the tangible. So when you want to share your ideas, you often record it, and when you put it into something like that, like sheet music, that's when that part isn't the copyrightable bit. So copyright is a form of intellectual property, as I've said, and in this definition, what's important for you to remember is original expression of ideas, and that you can manage how your content is being used. And there's a trick to copyright, and that is, how do you know someone's using your work? Well, you often don't, and possibly, someone might be misusing your work, which is your reputation. And in the element of the music that we talked about, you can see that copyright lasts quite a long time too. So in 3D, copyright owner is the creator, and that is someone who can demonstrate that sufficient skill or effort has been directed towards creating the piece of work. And this falls into such as the engineering, the design drawings, the architectural plans, that is your STL files or your object files. The truths about copyright. Well, copyright is applied as soon as the 3D artistic work is created. Even if the copyright symbol is not visible, copyright still applies, as I've said. Saying you don't know is not going to be a defence for plagiarism. And in general, copyright for something you've created will last 70 years after the creator's death. That's a hell of a long time, and it used to be 50, so they've actually expanded that. But not all copyright will last that long. You just really need to check. And just another note, a design can be registered. So once you registered your design though, copyright is forfeited. And also once you've made 50 articles for your 3D printing, the choice has been made for you. Copyright is null and void. So where might copyright hide? In the printing of a body part for educational and medical use. Your CAD file may be licensed, so please check before you use them. Making a copy of a CAD computer program solely for the purpose of education of medical students may be fair dealing, but it may not. Then you've got the CAD file. Is there copyright in a digital scan of a body part in a CAD file? Well, the answer will depend on the degree of independent intellectual effort involved in making the CAD file. However, if the maker has exercised creative choices to produce a CAD file from the digital scan, then there is likely to be copyright. The third one is there copyright in a 3D print of a body part? If the 3D print of the body part is to be used for medical purposes and not, for example, making an artistic sculpture to put in an art gallery, then the answer is no. And lastly, copyright in a database of CAD files. Well, there may be copyright in such a database as a whole if particular arrangement or format or ordering of that database has some original expression, but if it's just in date order or alphabetical order or something really common, then there's nothing to it. Myths. Well, I can use other people's content without their permission as long as I don't make any money out of it. You should all know the answer to that. It's no. Copyright still applies, you just need to seek permission. And Carmon yesterday, he did some excellent referencing on his slides, and he often referenced his own work, which is very smart because he knows that he's given away the copyright to his work and he can plagiarise himself. Fact number 2, I don't need permission if I copy less than 10% of a work. Well, no again. Using even a small part needs permission. 10% without permission is often in the area of fair dealing, and that's very much if you're a student and you're studying and doing research. I can use other people's work as long as I credit them. Again, the copyright owner may not actually care. However, they may wish payment depending on how you've used their work. So yesterday, Darpin, you might have noticed, put the CRC copyright logo on several of his slides, and that would give me the idea that he intends to perhaps use that information further on down the trail and make it commercially orientated. And I can use a work if I make changes. Well, we all know that's not true. You've got to be very careful around plagiarism these days. It's one advent of computer technology that can catch up with you very quickly, but also you can't disrespect the intent of the original work. And the last one is getting permission. Oh, that's just all so hard. Well, it just isn't anymore. Of course, we've got email, which we can find people quite easily. And the Copyright Agency, they also have an application now where you can actually register if you're going to use someone else's copyright. So all I need to say here is, like, be wise. If your organisation actually has a copyright policy, please make yourself familiar with it. And if they don't, perhaps you need to talk to legal counsel and get them to think about that. What I really like to bring to the table today is Creative Commons, and that's flexible copyright. And Creative Commons is about guiding others on how you wish your work to be created and used. If you don't create a copyright statement, a Creative Commons statement then copyright, as I've mentioned, will automatically apply. And copyright is so closely linked to commercialisation. But a Creative Commons licence is about sharing with acknowledgement and building on the work of others. Ideal for non-commercial focus of 3D printing. So, Creative Commons is a not-for-profit organisation that works to make it easier to share, reuse, repurpose, remix creative material. It does this by providing free licences to let creators give permission in advance, which is very efficient, for certain uses of their material. So they highly encourage sharing. And what I really like about the Creative Commons licences is you can build them yourself. They have 4 variations, as you can see here. You can use one, you can use all 4, you can make a combination of any. It's up to you to decide. And how are you going to sort of make that decision? Well, look, they've even put together a lovely flowchart for you, which is very easily printed off the internet. The internet has everything these days. So if you started with the green box, am I okay with other people's copying and distributing of my content without asking my permission every time? If your answer is no, then you're still in the realm of copyright. But if you follow the 2 pink boxes down, then you're sort of allowing some remixing or use of your work. The blue boxes sort of represent where you're moving into a slightly sort of commercial space, and the purple is really where your licenses fit. And I can just, as you can see, there's also symbols there that you can use just to make this a little bit clearer. But wait, there's a lovely picture here which has your icon, the description of what your icon means, and also an acronym if you want to put that on there. Yes, we could have even had a test on this later in the day, but it's Sunday afternoon. So that really just wraps up. I really feel quite passionate about Creative Commons, and I think it's definitely worth pursuing in the realm of 3D. Printing and making your models, because if you express your wishes up front, then some decades later you don't know where the future is going to take you, and you don't want to end up in court. And I have to put in a plug for librarians, of course, because we always have helpful hints. So I'd like to also acknowledge Ben Hopper, who produced a paper which we've got up on our website, and of course he's got a Creative Commons license on it, but I also asked his permission to use some of his work for one of my slides today. So thank you very much.